Welcome to the Law Offices of Chris M. Ingram podcast. We're excited to continue our new four-part series on what to do when an American marries a foreign national in the U.S. and now wishes to keep their new spouse in the U.S. and complete all the necessary paperwork here. If you or someone you know is in this situation, then this is a great podcast series. Let's dive into part 2 of this four-part series. Before we get started, we would like to acknowledge Attorney Chris Ingram and his dedicated legal team. They did a great job researching and preparing this material for us, and they would love to work with you.
Disclaimer. Please note that this podcast should not be regarded as providing legal advice specific to your situation. If you'd like to book a free consultation, please visit www.breakthroughusa.com.
We are thrilled to be able to present this topic for you today. It's full of fascinating and really critical information. So in part 1, we launched our journey through the adjustment of status, or AOS, process. We really explored that critical concept of immigrant intent under Section 214B INA.
Right. That's a really foundational element, isn't it? It dictates whether someone, intended to stay permanently when they first entered the U.S.
Exactly. Because a non-immigrant visa, like a tourist visa, is for a temporary stay. Mm-hmm. And USCIS looks very, very closely at whether there was any sort of preconceived plan to marry and stay right from the get-go.
Mm-hmm. It's crucial. They scrutinize that intent meticulously.
We also looked at the rise of U.S.-based international marriages, the general eligibility criteria for AOS, which essentially means applying for your green card while you're already here in the States.
Instead of going back home for consular processing.
Right, and we covered those crucial initial steps like filing Form I-130, the petition for alien relative, and Form I-485, the actual adjustment of status application.
Yeah, we really laid the groundwork, touching on the initial evidence needed and some common pitfalls right at the beginning. And a key part of that initial deep dive was highlighting how Attorney Chris Ingram and our legal team use their extensive expertise, especially with those 500-plus video tutorials, to help couples navigate what feels like a pretty relentless USCIS enforcement climate in 2025.
Relentless is a good word for it.
It really is.
Yeah.
I mean, this isn't just about filling out forms correctly anymore. It's about navigating an increasingly complex, heavily scrutinized environment. Even small discrepancies can trigger intense reviews or, frankly, denials.
Wow.
And this heightened scrutiny, it really impacts every single step of the journey, from that initial filing right through to the post-approval requirements we're talking about today. It definitely sets the stage.
Okay, so our mission today is to unpack what happens after that initial AOS approval. Because, getting approved is such a heartwarming milestone, right? A huge moment of relief, celebration for couples.
Oh, absolutely. A massive weight off their shoulders.
But the path forward, it still demands incredibly careful navigation. We're talking about post-approval requirements, critical travel considerations.
Especially under that unforgiving 2025 USCIS enforcement climate we just mentioned.
Exactly. You might think, okay, the hardest part's done once you get that initial approval. But this next phase, it has its own unique set of, complexities and potential pitfalls that can still derail your path to permanent residency.
And what's fascinating here is how our researchers really emphasize that the legal guidance you choose can truly make or break your journey in this next phase, which is just as critical.
Make or break. That sounds serious.
It is. Relying on, say, unlicensed consultants who just don't have the legal training or the accountability of licensed attorneys or even less experienced attorneys, it risks turning your American future into a real nightmare. Our legal team, they've seen countless cases where that initial success was completely jeopardized by missteps in these later stages. It just underscores why meticulous guidance, like the kind offered by Chris and his team, is absolutely essential. They get the intricacies of these post-approval steps and know how to proactively tackle potential issues.
Okay, so today we'll delve into those necessary post-approval steps you need to take, to move from temporary status to permanent residency. We'll cover the significant travel challenges and re-entry risks. Those can catch anyone by surprise, right?
Oh, definitely. And lead to devastating consequences if you're not prepared.
We'll also talk about the cultural and bureaucratic adjustments you'll inevitably face settling into life here and run down some common mistakes to absolutely avoid.
And we have a case study that really brings it all home.
Yes. A compelling case study that draws you right into the stakes of this journey illustrates how these complex issues play out in real life. Okay, let's unpack this. 1, the sweet taste of success, Elena and Michael's outcome. Let's start with a moment of triumph, some validation. Remember Elena and Michael from part 1? Their story was kind of foundational, showing those initial AOS challenges, especially establishing Elena's lawful immigrant intent.
Right, the 214B issue.
Exactly. Well, our team kept following their story, and we now have their resolution. Picture this. Their hearts are racing as the Austin USCIS officer reviews their meticulously prepared AOS application.
You can just imagine the tension in that room.
Yeah,
All those months of paperwork, preparing for the interview, just hoping.
absolutely. And after what must have felt like forever, a thoughtful pause, the officer's stern look just softens. The pen taps. And she approves their case, granting Elena conditional permanent residency.
Wow, what an incredible moment for them. Just pure relief and joy.
Totally.
And what's really impactful about their story, according to attorney Chris Ingram, isn't just the approval itself, it's the broader legacy it created for their community.
Oh, interesting. How so?
Well, 9 months later, and this was a direct result of them successfully getting through this process, their bilingual school opened its doors in Austin.
No way. That's amazing.
Yeah. Imagine classrooms just alive with Spanish and English, empowering immigrant kids with that invaluable gift of dual language learning, cultural understanding. It really underscores the profound, ripple effect of successful immigration.
That's incredible. It goes way beyond just the couple.
Exactly. It enriches the whole community, creates tangible positive change, fosters a more inclusive society. It's really a testament to how meticulous legal work can enable dreams that benefit everyone.
So what does this mean specifically for their success? Our legal team highlights how their careful guidance and those accessible video resources really crafted a robust, compelling case for Elena and Michael.
Right. It wasn't just about filling forms, it was strategic.
Strategic how?
Building a compelling, undeniable narrative, showcasing the authenticity of their relationship, and, crucially, Elena's lawful entry intent. They prepped them for every possible question, anticipated challenges, from the really technical legal stuff to, nuanced cultural perceptions.
Okay, so anticipating problems before they happen.
Exactly. The big challenge they faced was overcoming that stringent USCIS scrutiny, especially with the tougher 2025 enforcement climate. Chris and his team helped them avoid those critical pitfalls that often trip people up.
Like what kind of pitfalls?
It's like presenting weak evidence, inconsistent information, or just not enough proof. And crucially, they focused on ensuring Elena's lawful entry intent under Section 214B was clearly established and communicated.
So, proving she didn't plan to stay permanently when she first arrived.
Precisely, providing irrefutable proof. Our attorneys helped them gather evidence showing Elena's original travel plans, her strong ties back home at the time of entry, and how her relationship with Michael developed naturally, organically, after she entered legally.
Okay, that makes sense. It's building the story.
It's building a solid, undeniable narrative backed by strong, comprehensive, well-organized documents, leaving no room for doubt or suspicion in the officer's mind.
And the lesson here seems profoundly clear. Choosing quality legal counsel over, say, unlicensed consultants or less experienced options really kept their American dream alive, kept them on track.
Absolutely. It's a testament to the comprehensive support and, frankly, the confidence instilled by resources like those Chris and his team provide.
You might think you're saving a few bucks going with a cheaper option.
But the risks, as we'll explore more, are just way too high when your entire future in the U.S., your family's well-being, your ability to build a life here, it's all on the line.
Yeah.
The difference between success and, devastating setbacks often boils down to the depth of expertise and foresight of your legal team, especially now, facing this increasingly rigorous system.
2, strengthening your residency.
This national post-approval system.
Okay, so your AOS is approved, huge hurdle overcome. But, and this is important, for many people it's not the finish line, right? It's a big step, but on to the next stage.
Exactly. If you've been married for less than 2 years when your AOS application gets approved, you don't get the permanent green card straight away.
Right. You get what's called a conditional green card.
Yeah.
Typically valid for 2 years.
And understanding this conditional status is incredibly important. It's not the permanent solution many assume. It's more like a probationary period for your residency.
A probationary period.
Yeah. It means you still have vital work to do to secure your permanent residency to get those conditions lifted. Our attorneys emphasize this 2-year period is all about continuing to prove the authenticity of your marriage, beyond any doubt.
And that's especially critical now with the 2025 enforcement climate.
Absolutely.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
USCIS isn't just looking for proof you got married back then. They want undeniable proof your marriage is bona fide, meaning real, ongoing, committed, entered into in good faith, not just for immigration benefits. They're really vigilant during this period for any signs of marriage fraud.
So to maintain this status and ultimately transition to that 10-year permanent green card, you have to provide ongoing, substantial proof of your marriage. And it's not just wedding photos, right?
Not at all. Lovely as they are, they need more. They want to see your lives are truly intertwined, practically, financially, emotionally, demonstrating a shared life and a shared future.
So what kind of proof are we talking about?
Our researchers stress robust, current, and diverse evidence. Think beyond the obvious. Joint financial records are huge bank statements showing shared funds, joint credit cards, joint tax returns. That shows a shared financial life.
Okay, money stuff. What else?
Utility bills, electricity, gas, water, internet in both names at your shared address. A joint lease or mortgage is vital proof you live together.
Makes sense. Proving cohabitation.
And beyond documents, shared experiences count. Provide shared vacation photos taken after the initial approval showing you're building no memories, evidence of joint insurance, health, auto, life, shared memberships, maybe a gym or a club, any joint assets you've acquired, like a car title or property deed.
Wow, okay. It's pretty comprehensive.
It is. Even affidavits from friends and family who can genuinely attest to the authenticity and, importantly, the progression of your relationship. These should ideally be from people who see you regularly as a couple, not just distant relatives. They should detail specific examples of your shared life.
Okay.
Our team's video tutorials give really practical step-by-step tips on how to meticulously gather, organize, and keep updating this documentation throughout that 2-year conditional period. You need a strong, evolving narrative of your marriage.
And then after those 2 years from the initial conditional approval date, you have to file a new petition.
Correct. Specifically, Form I-751, Petition to Remove Conditions on Residence. This transition to the 10-year green card is a separate process. Another significant milestone requires its own application, its own review.
And we'll cover that I-751 process in detail in part 4 of the series, right?
Exactly. It's basically another application, another critical round of submitting updated evidence, and potentially another interview to definitively prove your marriage is still genuine and ongoing.
Got it. And beyond that, you mentioned work and travel authorizations.
Yes, securing and maintaining current work and travel authorizations is vital to fully, embrace life here. While the conditional green card grants many rights, having explicit, unexpired work authorization, usually through the green card itself, ensures you can legally work without issues.
And travel authorization, we'll get into that more.
Yes, we'll discuss that in depth next. It's absolutely crucial for any international trips. Being diligent about these things ensures you're complying with all USCIS requirements, preventing future headaches, complications, or issues with your status. Our team provides tailored guidance on this, helping clients understand the documents, expiration dates, and how they fit into the whole picture.
And be prepared for processing times for these post-approval steps, right? Our legal team indicates the I-751, for example, can stretch to, 14 months, sometimes longer?
Yeah, easily. In the current 2025 climate, absolutely. That's a significant chunk of time, almost another year and a half, where you're waiting, operating under conditional status, maybe with an extension stamp. It's not immediate. Patience and unwavering diligence in keeping your evidence up to date are key.
Definitely sounds like it.
Indeed. And the intensifying USCIS enforcement climate demands meticulous, comprehensive documentation to avoid delays, requests for evidence, RFEs, or worse, denials. This is not the phase to cut corners, get complacent, or submit anything less than perfect. Every piece of evidence needs to be organized, updated, presented clearly.
And that's where good counsel comes in.
Absolutely. Chris's passionate support helps keep your green card status secure, safeguarding your path to permanent residency from the pitfalls of this really rigorous landscape. Don't let a lack of experience or relying on unlicensed counsel jeopardize your progress. The consequences of errors at this stage can be incredibly severe, losing your conditional residency, even facing deportation.
3. Navigating the minefield. Travel challenges and re-entry risks. Okay, let's talk travel. Imagine this scenario, and you hear about this kind of thing happening. You've applied for AOS, you're waiting maybe for the conditions to be removed, and boom, you get an urgent call, family emergency back home, a parent is gravely ill, maybe a sibling needs immediate help.
A terrible situation.
And your heart just says, go, be there.
Yeah.
But the stakes for your immigration status here are incredibly high. It's a really agonizing dilemma being caught between family duty and your future here.
This is precisely where planning ahead becomes absolutely critical, not just important, critical. Our attorney Chris Ingram highlights a severe, often irreversible risk here.
Okay, what is it?
If you've overstayed your underlying non-immigrant visa, say your B2 tourist visa expired, or your F1 student visa ended leaving the U.S., can trigger immediate statutory reentry bans under INA Section 212A and B.
Well, hold on. So just leaving can trigger a ban, even if your AOS is pending?
Yes, if you've accrued that unlawful presence and you leave without the right document. This law is specifically designed to penalize people who are unlawfully present for a certain time and then depart. The moment you physically cross that border without specific pre-authorization, you can unwittingly activate these devastating bars.
And these aren't minor bans, you said, not just an inconvenience.
Absolutely not. We're talking extremely serious consequences. Specifically, there's a 3-year bar if you were unlawfully present for more than 180 days but less than a year. That blocks reentry for 3 years from when you leave.
3 years.
And a devastating 10-year bar if you were unlawfully present for 365 days or more. A full decade-long ban on reentry. These are real, often catastrophic consequences for people who just don't understand the rules or assume their pending AOS protects them or don't get proper legal advice before traveling. Our team stresses, without an advance parole document, leaving risks automatically abandoning your entire AOS application. Or worse, triggering these long-term bars, turning your American dream into a nightmare. Your green card application can literally be deemed abandoned the second you leave U.S. soil without this specific permission.
Okay, so what's the key? How do you navigate this minefield? It sounds like advance parole is the magic phrase here.
Precisely. Advance parole allows for safe travel and re-entry during the AOS process without abandoning your application. It's basically a travel document from USCIS granting you permission to leave and come back while your green card application is pending.
Okay, that sounds essential.
It is, but, and this is crucial, the timing is everything. Our researchers consistently emphasize this. You have to apply for it early, ideally 3-6 months into the AOS process.
Not wait till an emergency happens.
Absolutely not. The application for advance parole itself, Form I-131, can take a significant time to process, often 3-5 months, sometimes longer, depending on backlogs. You need to anticipate the possibility of travel and apply well in advance as a precaution.
So what about emergency filings? Can you get it expedited if something urgent comes up?
Well, they're much riskier, and often they might not arrive in time, leaving you stranded outside the U.S. USCIS does have provisions for emergency advance parole, sometimes called humanitarian parole, but the criteria are very strict. The bar for approval is incredibly high.
So no guarantee?
No guarantee at all. And even if approved, processing can still be delayed. You might miss the critical event anyway, all while potentially jeopardizing your return. Chris and his team provide immense clarity through their video tutorials specifically on advance parole, when to apply, how to apply.
What kind of documents do you need for that?
Detailed travel purpose statements explaining exactly why you need to travel, concrete proof of an emergency like original medical letters from doctors, hospital records, maybe death certificates, all translated if needed. They make sure you submit everything necessary to bolster your case for timely approval, minimizing those risks.
Okay, this is definitely a situation where expertise truly matters. Crafting those applications precisely.
Absolutely. Our legal team crafts presents applications, often filing for advance parole concurrently with the initial AOS application, ensuring timely submissions to protect your green card journey from these devastating travel pitfalls. Choosing a less experienced lawyer, or worse, an unlicensed consultant here. It could lead to catastrophic delays, abandonment of your application, or, like we said, a complete statutory ban from reentry.
Okay, so that covers the travel minefield. But the legal forms are only part of the challenge, right? There's the whole settling in aspect. Here's where it gets really interesting. 4, finding your place. Cultural and bureaucratic challenges. Beyond the legal forms, the processing times, just settling into daily life here as a foreign spouse brings its own unique set of challenges. It's this mix of excitement and hurdles, right?
Definitely. It can be exhilarating one day and incredibly daunting the next, especially, as you mentioned, under the tense anti-immigration climate of 2025, which can amplify both the scrutiny from authorities and the social challenges you might face in the community.
You're not just navigating a new legal system, you're adapting to a whole new way of life.
Exactly. And one of the most common, often underestimated obstacles our team sees is cultural adjustments. Language barriers, even if you speak some English, can feel incredibly isolating day to day. Simple tasks become surprisingly difficult.
Like ordering coffee or understanding local news.
Right. And then there's the emotional toll. Homesickness is very real, very pervasive. You're navigating new traditions, new social circles, unfamiliar surroundings, often far from family, friends, your established support network.
Yeah, that must be tough.
Think about adapting to American holidays, Thanksgiving, Halloween, 4th of July. They might be completely different. Or just understanding local customs, social norms, how people greet each other, workplace etiquette, even how you conduct everyday transactions. These can be subtle but really significant adjustments impacting your sense of belonging.
These subtle shifts, the unspoken rules, they can be just as daunting as the legal hurdles, couldn't they? Affecting daily life, mental health.
Absolutely. And then you have the omnipresent bureaucratic hurdles. They can test anyone's patience.
Like what?
Securing essential documents beyond the green card, a social security number, a driver's license, that can be a whole convoluted process itself. Accessing the complex U.S. healthcare system, utterly bewildering, even for citizens, with its insurance plans, networks, billing.
Oh yeah, healthcare is confusing for everyone.
Totally.
You finally got your family together on a H-1B. Your American dream begins. Your employer files for your EB-2 green card, but the wait is over 11 years. As the years go by, frustration grows, and now the company is talking about layoffs. This could be the end of your American dream. You search for help, but luckily, you land on breakthroughusa.com. They listened, reassured you, and built your EB-1 case with precision. Then one day, a notification buzzes, EB-1 approved. With your EB-1 green card, your entire family can breathe.
I have got my visa. I got my visa.
That's why the law offices of Chris M. Ingram is trusted. Your future shouldn't wait. Let's talk EB-1.
What are the next steps?
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
Dealing with overwhelming forms for everything, school enrollment, bank accounts, and experiencing inevitable delays. Our researchers emphasize that while these processes are designed for clarity, they often feel anything but. It creates significant stress. It's like learning a whole new administrative language.
So for someone listening who's going through this, beyond the legal battle, how do you find your footing? How do you thrive?
Well, another difficult reality, especially with 2025's intense immigration debates, is the potential for social challenges. Prejudice can surface.
Sadly, yes.
Whether it's microaggressions or overt discrimination, it can affect your integration at work, in school, in the community. Subtle biases, feeling overlooked because you're foreign-born, or outright discrimination impacting jobs, housing, even personal safety. It's a sad but present reality that adds another layer of difficulty.
This is where attorney Chris Ingram and his team, based on the material, go beyond just the legal needs, right? They seem to get the bigger picture.
Indeed. Our researchers highlight how they connect clients with vital community resources, things beyond just legal advice. Recommending language classes, crucial for communication. Connecting them with cultural organizations, helping people connect with their heritage or explore American culture. Guiding them to job networks, professional development resources to ease into the U.S. workforce.
That sounds incredibly helpful.
And their video guides, available 24/7, offer practical, step-by-step tips on navigating bureaucracy, applying for work authorization, understanding healthcare enrollment, insurance jargon. These resources are designed to empower you to thrive, not just survive.
Build a stable, fulfilling life.
Exactly. It's clear Chris's dedication is to client success, ensuring personalized care, helping you build a strong foundation, rather than risking integration by relying on unlicensed consultants who might just focus on the bare minimum legal stuff, completely missing these crucial aspects of successful settlement and well-being. That holistic approach makes a huge difference.
5. Avoiding pitfalls. Common AOS mistakes. Okay, let's pivot to avoiding potential disasters. This post-approval AOS phase is critical. Even seemingly small errors can jeopardize your green card, especially now under 2025's intensified USCIS scrutiny, which demands basically flawless execution. Diligence.
Absolutely. This is not the time to relax or assume things will just work out.
Right.
Our attorneys, drawing from, extensive experience with countless couples, have identified several key pitfalls. And these aren't theoretical, these are real mistakes with severe consequences. Understanding them is your first line of defense.
We touched on this, but it needs repeating with huge emphasis because it's probably one of the most common and devastating mistakes. Traveling without advance parole. Monumental risk.
Cannot stress this enough.
Departing the U.S. without that specific document risks triggering those 3- or 10-year reentry bans or automatically abandoning your whole AOS application. It can just unravel everything.
Think about it. Urgent call, critically ill parent. Instinct is to leave. Doing so without advance parole halts your entire case. Stranded outside the U.S., no legal way back, green card application canceled. It's heartbreaking.
So the solution is always get advance parole first.
Always. Attorney Chris Ingram's video tutorials meticulously explain its importance, guide you on timing, apply early, 3 less 6 months into AOS, as soon as the I-485 is pending and the required documents. Like detailed travel purpose statements, supporting evidence like medical letters, death certificates, the message is crystal clear. Secure advance parole before any international travel. Waiting is not an option. Processing takes time. Emergency criteria are narrow.
Okay. Mistake number 1. Travel without advance parole. What's another common one?
Another incredibly common oversight, even after initial approval, is failing to provide ongoing, continuous marriage proof, especially when it's time to remove conditions with the I-751.
Why is that so crucial? You already proved it once.
Because USCIS isn't satisfied with just the initial proof. That oversight can significantly delay condition removal, or worse, raise serious fraud concerns leading to deeper investigations. They expect robust, ongoing, evolving evidence to continually confirm your marriage's authenticity over that 2-year period.
Okay, so what does ongoing, evolving evidence look like?
Regularly updated recent joint bills, utilities, phone, credit cards, updated shared vacation photos from trips taken since the initial approval, current financial records showing commingled assets, joint planning, joint insurance policies, health, auto, life, property deeds or leases in both names.
So keeping the documentation fresh.
Exactly. And strong, updated affidavits from people who see you regularly, neighbors, colleagues, friends, attesting to your genuine shared life, your integration as a couple. Our video guides detail exactly how to compile comprehensive, compelling proof, organize it, highlight the most impactful stuff, demonstrate a truly integrated and evolving marital life. It avoids this common oversight and strengthens your case significantly.
Okay. What about interviews? If USCIS requires a follow-up interview, maybe for the I-751 condition removal, being unprepared is bad news.
Major problem. You might assume, oh, I had one successful interview, the next will be easy. Dangerous assumption.
Why?
Unclear, inconsistent, or hesitant answers about your marriage immediately spark doubts. Couples unprepared for detailed questions about daily routines, sharing finances, future plans, integrating cultures often falter.
What kind of questions?
How did you celebrate your last holiday? What does your spouse do for work? Who does the cooking? Small details about your home, daily habits, fumbling, giving conflicting info. That leads to intense scrutiny, RFEs, even denial.
So preparation is key.
Absolutely. Attorney Chris Ingram's firm offers invaluable interview prep videos, personalized coaching. It builds confidence, teaches you to articulate your relationship's depth, authenticity, progression with clarity, consistency. From shared traditions to joint goals, this prep ensures you present a cohesive, convincing narrative, addressing potential concerns directly.
Okay, and the last big mistake, which seems obvious but keeps happening, hiring unlicensed consultants or inexperienced lawyers.
Regrettably, yes. A major pitfall. Non-attorneys or lawyers with less experience in this specific area frequently mishandle crucial post-approval steps.
How so?
They might submit weak or incomplete evidence, not understanding the nuances USCIS looks for in 2025, or, tragically, completely ignore critical travel risks, leading to people abandoning applications or getting barred from reentry, turning dreams into nightmares.
Give me an example.
An unlicensed consultant might just overlook the need for advance parole, directly causing a reentry ban if the person travels, or fail to guide you on providing the right ongoing marriage proof, triggering intense scrutiny and I-751 denial, even deportation proceedings. They often lack the comprehensive legal background, the up-to-date knowledge, the ethical accountability, especially with 2025's climate, leading to costly, often irreversible mistakes.
Whereas the law offices of Chris M. Ingram helps you actively avoid these errors. Tailor support, video resources.
Exactly. Ensuring your journey stays securely on track in this rigorous climate. Their deep experience means they've seen the pitfalls, know how to guide you safely, proactively addressing issues before they become crises.
6. A race against time. Case study Pretty and James. Okay, let's bring all this together now with a compelling real-world scenario. Meet Pretty. She's an Indian dancer from Mumbai, bringing Bharatanatyam's intricate storytelling to life in Chicago.
Beautiful art form.
Truly. She met James, a U.S. nurse, gentle guy but fierce dedication to community health, at a cultural dance workshop in Chicago back in 2023. Romance blossomed, late-night rehearsals, shared dreams.
Sounds lovely.
They dreamed of opening a cultural dance studio together, inspiring Chicago youth with Indian traditions blended into the city's diverse fabric. Their 2024 Chicago wedding was just radiant. Bharatanatyam bells, American jazz, James's ER colleagues, Pretty's sister's friends, all celebrating in a community garden.
A beautiful start, but then the adjustment of status process cast a shadow.
Yeah, and that shadow was magnified intensely by 2025's USCIS enforcement climate, scrutinizing applications with an iron grip, right?
Especially for those with visa overstays. And that was critical for Pretty. Her J2 visa had lapsed after her sister's student program ended. Her sister left. Pretty's dependent visa expired automatically. She was unlawfully present for several months before the wedding.
Making their case immediately high risk under the current climate, flagged for deeper review.
Precisely.
And James, juggling grueling ER shifts, studio blueprints, immense pressure. He made a grave error. Understandable, maybe, but grave. He hired an unlicensed consultant to cut costs, trying to save money for the studio dream.
A decision driven by financial pressure, maybe lack of awareness, but incredibly costly. Our team's insights here are stark, a real cautionary tale.
What happened?
The consultant's shoddy, hastily prepared petition. A disaster. Glaringly omitted critical evidence USCIS needs. Joint leases showing they live together, photos from dance rehearsals, social gatherings showing a real shared life, affidavits from Pretty's dance students and parents who adored her could speak to her community involvement.
All the stuff we just talked about needing.
Exactly. These huge omissions, a direct result of inexperienced counsel, immediately raised red flags. The documentation was just insufficient to prove a bona fide marriage.
So, Pretty's first AOS interview in Chicago.
The USCIS officer, emboldened by 2025's fraud focus, the lack of evidence, issued a notice of intent to deny the reasons. Insufficient proof of marriage authenticity and Pretty's visa overstay. That rejection felt like a curtain falling on their studio dream. Pretty was devastated, agonizing uncertainty.
And just as hope was waning, another crisis.
Yes. Pretty's beloved mother back in Mumbai fell critically ill, severe heart condition, needed an urgent visit from her daughter. And here's where those travel risks become painfully, immediately real.
Her visa was expired, AOS facing denial, leaving without advance parole.
Risked a 3-year reentry ban under INA 212, A9, and automatic abandonment of their AOS application. A classic, heart-wrenching dilemma, family emergency versus their entire future together in the U.S.
Frantic, desperate, James turned to the law offices of Chris M. Ingram, drawn by their reputation for expertise, success in complex, adverse situations. What did the team do?
Using our travel-focused video tutorials, their own deep experience, Chris and his team immediately grasped the extreme urgency, the dual crisis. Pretty needed to travel. The AOS case needed salvaging. They acted swiftly, strategically.
Okay.
Immediately filed for advance parole. Detailed, compelling documentation of the medical emergency hospital records, doctor's letters, family letters, all translated, certified. Concurrently, our attorneys completely rebuilt their AOS portfolio into a fortress of undeniable evidence.
What kind of evidence did they add?
Vibrant, unseen wedding dance photos, detailed emails outlining youth programs for the studio, joint bank statements from pop-up dance events showing shared finances, entrepreneurship, powerful new affidavits from James's ER colleagues who knew them well, personal testimony to their genuine integrated relationship.
Wow. A complete overhaul.
Total overhaul. And her coaching meticulously prepared Preeti for a follow-up interview. Taught her to affirm her lawful entry intent entered on a valid J2, no marriage plans then, and confidently address cultural differences, blending traditions, presenting a consistent, truthful narrative. Her biometrics, medical exam flawless, guided by our videos to avoid procedural errors.
So the follow-up interview in Chicago. High stakes. 2025 enforcement climate hanging over the room. The officer probes the rapid courtship, lack of initial evidence, the overstay.
Right, searching for inconsistencies. But Preeti, fortified by our coaching, the video tutorials, shared vivid personal stories choreographing a dance for James's birthday. Her words, the extensive new evidence, a powerful testament to their authentic love, commitment.
Well, there's a catch.
Yes. Even with the strong rebuild case, the advance parole application was still pending. Agonizingly close, but not yet approved. And Preeti's mother's condition in Mumbai grew dire, daily, pressing her to consider the unthinkable, leaving without the advance parole. A move that, even now, could permanently bar her return, shatter everything.
Oh, wow. So as the officer reviewed the file, paused on a video of her wedding dance, Preeti's clutching her studio logo sketch, heart heavy with worry for her mom, for the dream hanging precariously in the balance. So the agonizing question remains.
Would attorney Chris Ingram's swift action, passionate support, comprehensive video resources ultimately secure their green card, save their dream? Or would the unlicensed consultant's initial errors and Preeti's looming crisis, intensified by 2025's unforgiving climate, tragically shatter their vision of a cultural dance studio and a life together in Chicago?
You'll have to find out in part 3 of this series. We'll reveal Preeti and James's ultimate fate, dive deep into the specific causes of AOS denials, why cases get rejected, and share another couple's heart-wrenching struggle through a different set of challenges.
Wow, what an incredible journey we've taken through the intricacies of the adjustment of status process post-approval. We've really seen how crucial every single step is, from providing that continuous evolving marriage proof to the absolute non-negotiable necessity of advance parole for any international travel while your application is pending.
And the Preeti and James case study, it just powerfully highlights how professional, knowledgeable guidance, proactive legal intervention can make the decisive difference. The difference between achieving your American dream and facing devastating setbacks, even permanent bars. This deep dive into the material attorney Chris Ingram and his team provided really underscores that point.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Once again, we would like to thank attorney Chris Ingram and his team for researching and preparing this material for our presentation today. They are doing an awesome job.
Please leave us a comment if you can, as it really means a lot to all the staff. If you'd like to book a free consultation, please visit www.breakthroughusa.com. See you next time on Let's Talk U.S. Immigration. Bye for now.